This presentation is on our consultation paper, Getting Married, a Consultation Paper on Weddings Law. I'm Nick Hopkins, the Commissioner for Family Law, and I'm joined for this presentation by Professor Rebecca Probert, who is our expert consultant working on the project. This presentation is intended to provide an at-a-glance overview of the provisional proposals that we are now consulting on. It's designed primarily for members of the public, including couples who are interested in the changes that we are consulting on. If you're not familiar with the Law Commission, we are a body set up by Parliament over 50 years ago, and our job is to make recommendations to government to reform the law in England and Wales. Importantly, we act independently from government when making our recommendations. We published our consultation paper on the 3rd of September, and that has started a period of public consultation on the provisional proposals to reform the law governing weddings that we have put forward. Our consultation runs until the 3rd of December. To have your say on our provisional proposals, please send in your consultation responses. And if you look at our website, you'll find information on how to respond, including an online response form. So our project concerns weddings law, and by weddings law we mean all of the formalities a couple must go through in order to have a legally recognised marriage. So that includes the preliminaries to the wedding, sometimes referred to as giving notice of the marriage, rules about the ceremony itself, including where it can take place, who must attend and what must be said, and the registration of the marriage. Weddings law is currently governed by the Marriage Act 1949, but the law has developed incrementally over hundreds of years, and in fact much of the law contained in the 1949 Act date from the 18th and 19th centuries. And of course society has changed profoundly since then. We are much more culturally and religiously diverse, and we are also much more secular. Many people want to celebrate their weddings in unique and different ways. The current law is a complex maze of different rules for different types of ceremonies, all based on the particular building in which the ceremony takes place. It imposes restrictions on how and where couples can get married that exist for historical rather than current policy reasons. For many couples, how they wish to celebrate their wedding and how the law requires them to celebrate it simply conflict. And so I'm going to hand over to Rebecca Probert, who's going to take you through some of the main provisional proposals that we're now consulting on to change the law.
Thank you, Nick. So thinking first about the preliminaries that are required before all non-Anglican weddings. At present, there's a residence requirement, which means that every person must give notice of their intended wedding in the registration district where they've been resident for the past 7 days. Under our provisional proposals, they would be able to give notice of their intended wedding remotely and be able to choose the registration district where they attend to complete the preliminaries. We're also proposing change to the way in which notices of intended marriages are publicised. At present, they are simply posted up at the local register office, but under our scheme, they would be published online, accessible to the wider community. In terms of the types of weddings that are available, at present couples must choose between a civil or a religious ceremony, again for reasons dating back to the 19th century. There's no option to have a wedding according to beliefs that are non-religious. Our scheme, however, would enable weddings conducted by non-religious belief organisations such as humanists and potentially independent celebrants if government decided to permit them. We're also making proposals about where marriages may be celebrated. At present, with a few exceptions, all couples must have their wedding in a specific place, either a place of worship or a licensed secular venue. And this means that couples generally can't get married outdoors, even in the garden of a licensed venue. They can only do so if there's some formal structure within which they can marry. Under our provisional proposals, all weddings will be legally permitted to take place in a location that's chosen by the couple. And this means then that couples will be able to get married outdoors if they so wish, or in their own homes. A third set of recommendations look at the types of ceremony. So at present, all civil weddings and some types of religious weddings have to include certain prescribed words. And this can be quite restrictive, particularly within religious ceremonies. Under our provisional proposals, there are no prescribed words, which gives couples greater freedom to choose the form their wedding takes. And this will then enable the law to recognise the variety of ceremonies that people use to mark their weddings, including the wide range of religious ceremonies. There are also at present restrictions on what can be included in a civil wedding. The main restriction is that couples can't include elements that reflect their religious beliefs. Under our provisional proposals, as long as the wedding is still broadly identifiable as a civil ceremony, couples will be able to have religious songs, readings and hymns as part of that civil wedding. We are also looking at the circumstances in which a marriage might be invalid for a failure to comply with the legal requirements. At present, if they do so either intentionally or without realising, the law might not recognise them as actually being legally married, with profound consequences for their legal rights and responsibilities. Under our provisional proposals, however, fewer ceremonies will result in a wedding that the law does not recognise at all. We've also, of course, had to think about how the law can cater for emergencies such as COVID. The pandemic has had a significant effect on weddings. For a time, of course, virtually all weddings had to be cancelled or postponed due to the public health laws which came into place to limit the spread of the virus, with only some weddings where one of the parties was terminally ill being able to take place. Now, public health regulations are outside the scope of our project, and our project is also not considering issues which can arise if a wedding is cancelled. We can't make recommendations that would allow a wedding with guests to take place in person if public health rules did not permit it. However, what we can do is consider how to allow the legal requirements of a wedding ceremony to be met so that a couple can become legally married during a future national emergency, such as a pandemic. Our provisionally proposed scheme already offers some advantages which could allow weddings to take place, for example, by allowing weddings to take place in a couple's home or outdoors. We also make a provisional proposal for a power that could be exercised during a future emergency to change the rules so that the validity of existing schedules, the authority to marry, could be extended. Both stages of notice could take place online. Ceremonies themselves could take place online by a video conferencing app, and registration could take place by post or electronically. Obviously, we hope that you will read our full consultation paper, and we invite you to respond to the consultation by the 3rd of December. And we look forward to hearing your thoughts on our provisional proposals.